Welcome friends, once again. Today I'm going to cover this judgment which is against Vardhman Amrante Private Limited, situated at Chandigarh Road, Ludhiana. The date of decision is 25th of August 2020. Let us read what this judgment speaks about. So I'm going to scroll down. There are multiple complainants, so therefore they have clubbed this into one common order, since all these three complaints involve similar question of law and facts. Now let us have the facts of the case first. The complainants, the size of the plot has been mentioned. The factual matrix is already quoted here in the table. The date of agreement is around 2014, 15 and 18, and the conveyance deed has already happened on 2015, 17 and 18. Now the case of the complainant is this, that the respondents have failed to provide the amenities and facilities as mentioned in the brochure which was given to them. According to them, the project should have community club, medical facilities, round-the-clock security parks, jogging tracks, sewerage plant, etc. And these are the things which on the part of the respondent is lacking. Now they have reduced this into specific violations: encroachment on green space adjoining plot V19, demolition of boundary wall of the project with a view to facilitate the construction in another project being undertaken by the respondent. Also, they contend that the completion certificate has not been obtained by the developer yet, and during the course of the case they have moved one application under section 34F, 35 and 3238 of Real Estate Act citing the violations. They have also cited one thing, that the respondent has put up an advertisement in Dainik Bhaskar on 19th of January 2020, wherein they say that a mall and a 10-screen multiplex is also coming up within the existing project. So therefore they are praying that this project should be stalled and respondent be restrained from selling any space of commercial complex without obtaining any approvals or registration from the authority. Now let us hear what the respondents have to say on this. The respondent on the very face of it says this is abuse of process of law, as we see in the pleadings. They say that they have provided all the amenities which the complainants are saying it is lacking, like jogger tracks, parks, security services and space, medical facilities, sewerage treatment. However, they say that the sewerage facilities have already been provided and the community center construction is also in the full swing. They also brought the notice of the authority to the fact that this was an unauthorized colony which has been subsequently regularized under the policy of Punjab government. So in that there is no provision of completion certificate. Therefore they claim that it is not an obligation to them to achieve it. Further, the advertisement that the complainants are citing, it does not mention commercial center with a mall or multiplex would be a part of the current project. So no details are mentioned in that advertisement. That they say that this is just an harassment exercise. The builder has further entered into an agreement with another firm for the development of the mall and the commercial complex, and hence they are not liable to meet any demands of the complainants as cited in the case. So now coming to the arguments, what were the arguments in this case? Let us hear them. Let us have this para number 5. The council says that the amenities and the facilities were promised that they were be given at the time of possession of the units, but since the possession has been given, it's not been given to the complainants. And the residential project hosts only 30 shops within its boundary. No commercial complex or mall has been ever promised to the residents or complainants. The new project is coming under the name of 1 Oswal. So they say that the project is in violation of the laws, and the completion of the project as submitted to the authority is dated 13th of September 2024. So by then the respondent builder will be completing all all those things which are mentioned in the complaint. Now, in the advertisement that the complainants have cited, the builder says that it was regarding only sale of plots and villas without mentioning the part of the existing project. And most of the sale deeds have already been executed. So changing the layout at this stage would be a strong contravention. That is what the complainant has to say. Now, the respondent, in reply to complainant's averment, they say that the agreement covers an arbitration clause, and the agreement also provides scope for the builder to carry out development and construction activities, and hence the authority is not having the jurisdiction to hear this complaint. Now, in the further paras, para number 6, the authority is observing these issues and given a finding on it. Let us see what kind of a finding the authority is giving. Authority denotes that though the possession has been given and the facilities at the premises are to be given, but since this is an unauthorized colony which has been regularized under the government policy, there cannot be a question of completion certificate. It is altogether a different case which this authority is dealing. So as per law, the completion certificate requirement is gone. Now coming on to the next part, that there is an advertisement of upcoming commercial mall. So authority is taking a cognizance of this and noting in its order that the advertisement has come up, but it has the same number of the registration number of the same of the residential project. So there seems to be a violation. So authority has taken the cognizance and noted in their order that this is a violation, and therefore the authority further in its order says that the legal proceedings on the administrative side shall commence against the respondent builder, since they have advertised the same commercial mall under the same registration number. This shouldn't be the case. So they are noting this in the order. Para 7 says respondent number 1 is prima facie held to be violation of the act, that they have advertised a commercial project with the same registration number, different agreement for sale in the case of Santosh rather than the one submitted to the authority at the time of registration. So necessary actions may kindly be taken up. Further, they are giving a direction to Commissioner Municipal Corporation Ludhiana that they need to see the layout plans at the time of regularization. If in case they are making any changes, it has to be done in the accordance of law. And in case they have violated or they have endorsed something, then the particular necessary action may kindly be taken up. Further, for the non-completion of facilities, as authority is quoting that the date of completion as per their record shows September 2024. So there is still time left with the respondent builder. So this will be taken care then. So they have given time to the respondent builder to complete it. So therefore the authority disposed these complaints on these findings and thus met out the result. So this is the judgment against the builder Vardhman Amrante, situated at Chandigarh Road, Ludhiana. So hope this judgment is of use to you people, and I am being able to walk you through this judgment, and you are able to make it out that in case you are living in this project or having any query regarding to this, so what can be the fate of your case. So I hope this is useful. Keep coming back to my channel, do subscribe, and in case you have any queries or question, feel free to call me. You can always visit my website by the name of legalseva.net, wherein I am bringing these short legal digest on judgments to the people out. So this is all I have to say today. Thanks for watching. Keep coming.